I'm Cheryl Angeles, President and CEO of the San Mateo Area Chamber of Commerce. Very pleased to have you on this morning to our bi-weekly, twice-weekly Business Essentials. And very excited to have Nicole Warmerdam speak about this very important topic today. I just recently had to go through this myself, and it is complex and overwhelming and all of those other things. And my mother was quite organized when she passed. But anyway, I am going to let Pauline do the introductions, and then please stay muted until the end. If you have a question, put it in the chat box and Pauline will unmute you when Nicole's ready for questions. Okay, thank you so much.
Great, thank you, Cheryl. Nicole is a board-certified specialist in trusts and estates. She's dedicated her 15 years of practice to counseling clients regarding a broad range of estate planning and administration matters, including drafting and implementing their estate plans, petitioning the probate court to resolve issues relating to estates and trusts, and navigating the process of administering estates and trusts after death. Prior to opening her own firm, Nicole worked for several preeminent estate planning firms in Northern California and Southern California that concentrated in both basic and complex estate planning and administration. Nicole strongly believes in empowering individuals with the knowledge they need to ensure that they and their loved ones are cared for and their estate is protected. She frequently speaks at local community and civic organizations, business associations, and social clubs about trust and estate issues. Thank you, and I'll hand it over to Nicole, and please stay muted as Cheryl indicated. Thank you.
So good morning, everybody. Thank you for joining me. I'm going to go ahead and get my presentation up and running so that you can see it along with me. Okay, so again, thank you for joining me. Today we're going to be talking about some of the general duties and responsibilities of an executor under a will or a trustee under a trust. This is kind of a complex topic. There are subtle nuances. Every estate or trust is different. And so I'm really going to touch on the basic general administrative aspects that every executor or trustee is going to have to deal with. We don't have a lot of time together, so we're not going to do a deep dive. Now, I am an attorney, so of course we have some disclaimers. I just want to point out that I'm here today to hopefully share some information with you, but I encourage you not to act or not act based upon the information that I share today. So if you hear something that is of interest or is of concern to you, I'm going to recommend that you reach out to your trust and estates attorney and talk over that issue, that concern, that need. And then finally, I just want to say, you know, obviously most of us here are probably joining in from sunny California. And estate and trust laws vary state to state, and also they do change over time. And so that is just something to be aware of. I know we're recording this, which is fantastic, but keep that in mind. So when I'm working with families that are dealing with the loss of a loved one and, you know, all of the associated grief, it can be a really daunting task to administer that loved one's estate or their trust. And really this is because the duties and responsibilities that an executor or trustee has, they start almost immediately after someone's passing. And so it's really important if you are nominated in a document, including your own documents, that you know what might be expected of you later on if you're acting in either of those roles. I will also point out, I don't want to scare anyone, but it's important to know that a trustee or an executor, they're acting in what we call a fiduciary capacity. And so what this term really means is it is kind of the highest standard that you can be held to. And so if you are not doing the right thing, it is quite possible that, you know, you may end up being liable to the estate, in particular if there are damages or losses for what you've done or not done. And so it's a really good idea, again, just to have, you know, some insight into what might be required of you. Now, I've kind of listed here everything that we're going to talk about today. I'm not going to go down this list because obviously we're going to be hitting all of these points, but it's a little summary there for you. Now, when you're starting out as an executor or a trustee, you are really going to be putting your inspector hat on. You are going to be looking for important documents. These documents are going to give you insights into what your responsibilities are. The will or the trust is going to tell you, you know, A, what you're authorized to do. And then, of course, you can let those third-party institutions know what you're authorized to do. But it's also going to let you know how you're supposed to administer the estate and where you're eventually going to be distributing that estate. Similarly, a healthcare directive, sometimes also known as a durable power of attorney for healthcare. These are the same thing. And any final instructions that the decedent left, these are going to give you valuable insight into, you know, their personal preferences. Did they want a funeral or memorial service? Did they want to be buried somewhere? If so, where? Or did they want to be cremated? You know, all of this information is likely going to be contained in those documents. You're going to want to keep an eye out as you're thinking about funeral arrangements. And, you know, burial arrangements and such. Keep an eye out to see whether or not maybe your decedent had kind of planned ahead a little bit. You know, folks are doing that more and more today. They're prepaying for those funeral arrangements, or they're buying those burial plots. And so, of course, if they've already done that, then you're going to want to respect that and, you know, use their arrangements versus making arrangements yourself. If you're lucky, you're going to find what I sometimes call a data recorder. It may go by different names. You know, we love to give everything our own little spin as estate planners. The data recorder is a document that your decedent may have put together, and it might include a list of their assets, a list of where to find important things, such as the will or the trust is in my safety deposit box at Bank X. And it might also contain information about things like passwords, because we live in an increasingly digital age. And so you may get a paper trail, but just fair warning, there is a little bit of, like I said, putting on that detective cap in the beginning and figuring out where everything is. So while you're doing all of that, you're also going to be responsible for reporting the death to certain agencies. As you might imagine, that's the IRS, the Franchise Tax Board, the Social Security Administration. One tip that I have for you is to change the address for the decedent's mail to your address, so you're getting it directly and on a regular basis. This is a great tool when you're gathering information, because you're going to get a bird's eye view, potentially into some assets you didn't know about, most definitely into any, you know, debts or unpaid expenses that the decedent may have had. You're going to want to notify the credit bureaus. This is important because they can put a notation on the decedent's account. You know, obviously that's going to help us avoid any potential fraud on that account. If the decedent owned real property, it's very important that you reach out to the county assessor's office. This is because death is considered a transfer to the beneficiaries, and usually that would mean a reassessment of the real property. There are some exclusions if you file paperwork, and so if the decedent owned real property, you're going to want to be reporting that death and seeing if you need to be filing exclusion paperwork. This is something that sometimes gets lost in the shuffle, so one key tip for you. And then again, you're just going to want to go through the process of notifying personal accounts. This might be the gym membership, the frequent flyer miles, etc., and notifying any, you know, banks that the decedent had accounts at. Now, if you're lucky and you're getting the mail, you're doing that research into the decedent's files, you're starting to put together a list, a good list of what the decedent owned. And that list is going to help you because you are going to need to collect, or sometimes we estate planners like to call it marshal, the assets And essentially what that means is before you can start administering things and doing things with the assets, you have to substitute yourself on title. Now, that doesn't mean you're the owner. You can't just kind of do what you want with the assets. You're going to go on title, again, in that fiduciary capacity. So you're going to go on title as the executor or the trustee. And then once you're on title, you can start managing the assets and getting them ready to be distributed. I have 2 tips when it comes to collecting assets. One is that the title of the asset or how it's owned is going to determine how you collect it. Some people think, oh, the decedent had a trust, so I'm going to go through and collect all the trust assets. But life is messier than that. So sometimes there are accounts that aren't in the trust, or accounts that, you know, maybe they had a joint tenancy interest in a piece of real property with a friend or family member. And so collecting a trust asset is going to be different than collecting the joint tenancy asset or a bank account that has a beneficiary that's named. So you're going to want to figure out what the title is, and it's probably going to be kind of an uneven process of collecting those assets. This is where a good trust and estates attorney can be very helpful. They can analyze this stuff with you. Similarly, you should keep in mind that a probate is going to be required if the decedent collectively, that means add it all together, had $165,000 worth of assets outside of a trust. Now, there are caveats such as joint tenancy property and whatnot. And so again, you'll have to go through the analysis of figuring out what assets aren't held in trust, what they may be worth, and then do they fit into any of those caveats so that we can avoid having to go to court and do a probate on those assets. Again, that analysis, it's very helpful to have a trust and estates attorney there to kind of guide you through the process. Another thing that you're going to be thinking about as you collect these assets is getting them revalued. This is important for 2 reasons. One, if you're going to be distributing the estate to a bunch of people, we very often don't go through and actually divide every asset into shares for those people so that everybody gets a little bit of bank account A and a little bit of bank account B and a little piece of real property C. It doesn't make sense if your estate's going to a bunch of people to have them co-own a lot of things. And so very often what we do is we value the entire estate, and then we divide that into shares. And then we say, okay, bank account A is going to go to this person, and bank account B is going to go to that person. And so they all end up getting the proper amount of assets, but they also can inherit something individually, and they can go off on their own and manage it. You don't have that co-ownership issue. So if you get all of the property appraised, then you know what it's worth, and it's very easy to divide into shares and figure out what is going to who. One additional very important reason for getting the real property valued has to do with income taxes. So when somebody dies, if you inherit property from them, you get what's called a step up in income tax basis. Essentially what that means is whatever basis they had before, it's going to now go up to the fair market value of that property at the date of death, which is why we get that appraisal. This is important because if you ever sell that asset later on, your capital gains or potential capital gains are going to be based on sales price minus income tax basis. So the higher that basis is, the less or hopefully no gain that you're going to have to pay. And so it is a real value to get those assets valued. Real property, it's just a basic appraisal report that you put in the file. With investments, you'll want to contact the bank or the institution that's handling those, and they will actually update it in their computer system and on their books. So once you've collected the assets, there's usually some period of time in which you're going to be managing them before you actually distribute them out to the beneficiaries. So I have some tips for you. The biggest takeaway, if anything, today would be do not commingle your individual assets with the assets of the trust or the estate. So what I like to see is individual assets over here and separate and apart trust and estates assets. Because remember, again, you don't own the trust or the estate asset. You are acting in a fiduciary capacity. You are taking You are taking over them for the time being so that they can eventually go to the rightful owner, the beneficiary. I do hear horror stories where, somebody says, oh, well, the trust needed money for this, so I loaned the trust, and then it paid me back here, and then this happened, and then that happened. Please do not commingle the assets, because that is a big no-no as an executor or a trustee. Some folks don't realize, but the whole sort of management aspect of an estate or a trust, this is a dynamic process. You don't just kind of collect it and let it sit there, and then at some point, it's time to distribute. Some of the things that you need to be doing are reviewing the insurance coverages. You want to make sure, A, that you have enough coverage, and B, that you have the right type of coverage. With real property, this is particularly important because you likely have a decedent who owned their own home. They had owner-occupied insurance. But when they pass away, that house then becomes vacant. And generally that requires a different type of coverage. So you need to reach out to the insurance company and adjust the coverages. If you decide that this is going to be a longer administration and maybe you're going to have a short-term renter come in and generate some income for the estate, then again, having rental property is different. And so you need to contact the insurance company and adjust the coverages. Similarly, you're going to want to review the investments. You're going to want to make sure that those investments are in the proper place, that they're generating income for the estate, hopefully, but that you are not in a portfolio with a really high risk indication. And so working with a good financial advisor is very helpful to just kind of make sure, do we need to make any tweaks here? Is there anything that needs to be done? And this is another area, the next point that I'm going to talk about, where I think people aren't aware of the potential issues if they're serving as executor or trustee, and that has to do with that rental real property. If the decedent owned rental real property, and this is whether it's a friend or a family member or it's a third party, a stranger, when you take over the administration of the estate, you need to look at the rents that are being collected, and you need to determine if these are fair market value rents, because again, you're managing and safeguarding the estate, and you have a duty to make assets productive. So that friend or that family member, if they were paying less than fair market value rent when mom or dad was alive, you may need to adjust that moving forward. And again, this is a protection for yourself as executor or trustee. And a couple little tidbits here. Again, keep an eye out for those property tax exclusions. If you can avoid reassessment, that's a huge deal here in California. But certain forms have to be filled out, and there are timelines for doing that. So keep that on your radar. And then if the decedent was actually taking out RMDs from a retirement account, you're going to want to make sure they took all the RMDs for the year of their death. Otherwise, you're going to want to go in and take out the rest of those. This is going to avoid some taxes and some penalties. Handling the debts and expenses. I mean, I think this goes without saying that when somebody passes away, their estate or their trust is liable for their debts and their expenses. So when that mail is coming in and you're seeing those bills, you need to be reaching out to those creditors, letting them know that the decedent has passed away and making arrangements to pay them. One fact that not a lot of people realize is the debts and the expenses, those bills, the IRS tax bill that may be coming down the pipeline, all of these things are paid off the top of a trust or an estate. And the beneficiaries only get what's left afterwards for the most part. And so, handling the debts and expenses is a very important part of what you would be doing. And keeping the beneficiaries informed. This is an area that I think presents the most problems for executors and trustees, and it most certainly results in the most litigation. And I'm not trying to slam anyone who is dealing with the duties and responsibilities of being a trustee or an executor. I think it can be a very daunting task. And so, many of us just kind of put our head down, we do the day-to-day stuff. And sometimes that beneficiary that's squawking, we just really don't deal with it. But this is a bad idea, because a beneficiary with a question very quickly turns into a beneficiary with a concern, and then a beneficiary with an allegation, and at the end of it, a beneficiary with a lawsuit. And so keeping the beneficiaries informed is an important part of the job. Now, first and foremost, you are required to send a notice that the decedent has passed away with a copy of the estate or the trust. But what I encourage you to do is to keep really good records for the estate or the trust. Maureen and I were chatting about that before the presentation began. Sorry to call you out, Maureen. But it can be difficult to keep really good records for an estate or a trust. And I don't mean collecting the bank accounts and putting them in a folder. So this is a good area where maybe a bookkeeper could be helpful in tracking the ins and the outs for the estate or the trust. This is going to be really, really helpful when that beneficiary, calls you up and asks you a question about the estate or the trust. You're going to have that information at your fingertips. Annually, when you're usually required to do an accounting to the beneficiaries, again, you're going to be in a really good position to put that together. Now, sometimes a beneficiary may waive the accounting, or the trust or the will itself may waive the accounting, but it's good to know that generally you would be required to do that and to be prepared to do that. And then lastly, I do want to talk about keeping records of your time. This is something that not a lot of executors or trustees do, and this is important for compensation. Now, I get a lot of folks that come into my office the first few months, they're just kind of getting the feel of it. And it's hard, but, not overly difficult. And so they say, I'm not interested in taking compensation. I don't need that. This is going to be quick. This is not going to be that difficult. Simple estate. And then 6 months down the line, 9 months down the line, and they're telling me I spent all my weekends on this and my evenings, and it's difficult, and I really do think that I deserve to be compensated for my time. So the compensation that you may see that's allowable under a will or a trust, usually it's this very unhelpful description of the trustee or the executor is entitled to reasonable compensation. Well, what does that mean? The industry standard is basically you're doing work for the estate or the trust. It's work that's beneficial to the estate or the trust. And we're going to essentially apply like an hourly rate, what you should earn for doing that work. And so I encourage people at the beginning, it can be an Excel spreadsheet. Put the date that you did something, what you did for the estate or the trust, and how long you spent. And then at some point, you're going to do some research, you're going to talk to a trust and estates attorney, and they'll come up with the hourly rate. And all you need to do is plug that in. And then if you do take compensation and somebody says, hey, now, where'd you get that number? Did you just pull that out of a hat? You've got the records to show, hey, this is what I did, and this is how I calculated it. And that's the way to do it. 6 or 9 months down the line, you can't really recreate that. All right, so I wouldn't be an estate planning attorney if I didn't talk about taxes. I'm sorry. You will be filing some taxes as an executor or a trustee. So the good news is you're probably not going to have to file an estate tax return. These are very complex returns. But because the exemption right now from estate taxes is $11.58 million, most people don't have to file an estate tax. You only have to file if you're above that amount. Now, you should know that that kind of moves over time. And so in 2026, for instance, that's going to go down to $5 million. But again, most of us are not going to have to file an estate tax return for a decedent. But you will have to file some income tax returns. You'll have to file the decedent's final federal and state income tax return. You're going to have to file administrative returns, and that's for the period of time from the decedent's date of death to when you make that final distribution. And sometimes that can, kind of jump over calendar years, and so you may be doing more than one income tax return for that administration. And then finally, sometimes you might be distributing to somebody in an ongoing trust, and so that trust would have its own annual income tax reporting requirements. The one tidbit that I would give you here is if you are thinking as an executor or trustee that you're going to file the administrative return or any of those ongoing trust returns on extension, talk to your beneficiaries and have them also file their individual income tax returns on extension. And this is because sometimes the burdens and the benefits from the trust may flow out to the beneficiary, and you want to make sure that everybody's on the same page in terms of what they're reporting. All right, so we finally gotten to the point. You've collected, you've valued, you've managed. Now it's time to distribute the assets of the estate. Really here, my guidance for you, follow the distribution plan laid out in the will or the trust or by the court if the decedent didn't have an estate plan. Now is not the time for any, side agreements or money coming in or out to do this or that. You are required as the executor or the trustee to follow that distribution plan. When you're distributing assets, you're going to want to make sure that you get signed receipts back. This is going to show that you made a distribution, when you distributed it, and what you distributed. This, again, is a protection for you as an executor or a trustee. And probably the second biggest tidbit that I can give you today, hopefully, is a lot of folks think, I'm distributing the estate. This is a final distribution, so I got to write checks out for everything, and then we're going to close it up and it's done. There are always trailing administrative expenses. It could be the CPA's last bill that they didn't get to you, or a medical bill that somehow got lost in translation and never made it to you. Or it could be something a little bit more unforeseen, like the IRS comes back and audits one of the tax returns you filed and says, hey now, we think the estate owes us more money. There are always trailing administrative expenses. And so you don't want to distribute everything. You want to hold back a certain amount of money. And this is going to be based on the size and the complexity of the estate. And you want to put that cash in a non-interest bearing checking account. Non-interest bearing is key because interest is income. And if you earn enough income, you have to file another income tax return after you've already filed all of those final income tax returns. So you get a bit of money, you put it in a non-interest bearing checking account. And then again, depending upon the complexity of the estate, you distribute that reserve amount in a year or 2 years or 3 years, and you get those receipts. I can't tell you how difficult it is if you don't hold back a reserve to go to all the beneficiaries and say, okay, collectively, I need $50 from you and $50 from you and $50 from you. Let's pull that money together and pay that bill. Because sometimes it's not $50, sometimes it's thousands of dollars. And so again, that hold back for you is going to be a lifesaver. Okay, so I do want to leave time for questions. What I've gone through today, again, is just a sort of general, very high level explanation of what every executor and trustee has to deal with. Obviously, there are more deep dives that can be done on many of these topics, and every estate or trust is different. And so you can imagine how complex an administration can be. So I do suggest you reach out to a number of advisors to potentially help you with an administration. A trust and estates attorney is going to be able to walk you through each one of these things step by step. And they're going to make sure that you understand how it applies to you in your position for your trust or estate. And they're going to be able to keep track of deadlines, make sure you're on track for getting that estate or that trust distributed in a timely manner. An investment or financial advisor is going to make sure that, you've got the investments in a good place. It's earning income, but not into risky of investments. A CPA or an enrolled agent that specializes in trusts and estates is going to be really important for that administrative trust return or those ongoing trust returns. And that's because individual income taxes and trust or estates income taxes are two totally separate tax regimes. They're absolutely different. And so having an individual do that who's not trained is never a good idea. Having a CPA or an enrolled agent who doesn't really do those day-to-day is also not a good idea. So I do recommend you work with somebody who's specialized in that area. It will save you a ton of heartache. And then again, a bookkeeper may be a good idea for those of us who don't really want to be keeping those detailed records or may want help with that annual accounting and whatnot. So that is all for me today. I am here for any questions, though, if anybody has any.
I had a question. You mentioned about the trust potentially being audited. How many years? Is it 7 years that you need to retain all the records? Or?
Yeah, generally, I think that is wise in terms of either an individual or a trust return is to keep it that long. What I often do when I am working with a CPA or an enrolled agent is you can actually submit a form, and I apologize, I don't remember, is it 4805 or 4804? But there's a particular IRS form that you can send in along with a return that says that they need to review it within 3 years. It essentially cuts short the potential liability. So if they have it sitting somewhere for a long time and they don't get to it, and then they don't assign somebody to it for a while, it is going to cut off so that you're not kind of out there in nowhere land. But I do always recommend, 7 years is a good measure, because you just don't know.
Thank you. And I actually posted something about the RMD. You don't have to take them in 2020 due to COVID. And if you did take them, you can put it back.
Thank you. That is a very good point. It is a very different year. I appreciate that. Absolutely.
I have a question.
Yeah.
I have a check from my mom's estate. It was actually from her utility company that she had overpaid. It's not a very large check, but I tried to deposit it. So they made an error, then they put my name on it, and but the wrong address. Okay. So do I just need to take in a copy of the executor papers? Will that take care of that?
So you said the check is in your name? Mm-hmm. Okay, so if you take in, no, it should have come in the name of the estate, and then you would take in the paperwork and deal with that. Since it's come in your name, essentially what you can do now, have you distributed the estate, or what status is the estate right now?
Yes, everything's, okay. Yeah.
So, I mean, I would recommend, this is one of the situations, again, there are gray areas aplenty in estate administrations, and everyone may have a different answer. I would say if it comes in your name, I would go ahead and either deposit it or cash it, but I would then distribute it to the beneficiaries, maybe with a little explanation, and get a receipt for it. That's kind of all you can do. Or, I mean, I guess you could actually go back and see if they'll recut the check in the name of the estate. Sometimes they won't do that. But, these are those little sort of trailing things that can happen, and we just try to come up with an interim solution, especially since you've already distributed most of the estate. I think it's a little bit of a no harm, no foul. Get it to the right people and get your receipts.
Okay, thank you.
Nicole, how long, I know Diane was talking about the 7-year keeping records. How long should you hold back that reserve in case of, bills coming in?
So that really is a case-by-case basis. I recommend at least a year. I often try to recommend 3 years, but sometimes for a simple estate with not a lot of assets, and we kind of know what the tax liability is going to be, and there's really no concern that we're going to have some surprise tax bill, then we might save a little bit less for a little bit shorter period of time. I mean, ideal would be a nice big reserve for 3 years, but sometimes we need to adjust that for a smaller estate. Everybody's so shy.
Any other questions?
I have a question. Sorry, Pauline, I can't use the chat feature. Nicole, what about digital assets? Is that how would you recommend handling that?
So for most fairly current estate plans within the last maybe 5 years or so, we are really building in protections for digital assets that essentially specifically state that the executor or the trustee is the person who is authorized to marshal them. And so, you can go through and contact, the Facebook or the cloud storage company, et cetera, with that authorization, and then can work with them to decide what to do with the account. Or the information contained in the account. because they have their own specific default rules. And so if your trust and estate doesn't address them, very often their default rules, like a lot of institutional default rules, are the executor of a probate estate. And so if you have a trust and you don't need to do a probate, that can be problematic. And so it is important to have estate plans that deal with that. If somebody has a data recorder, I love it, whether that's a digital data recorder or a written one, which is a little bit more risky when it comes to passwords. But having those passwords, you know, tied to those accounts in a secure way that, you know, your executor or trustee can find, leave them a trail that leads to it, then that's going to be really helpful, because a lot of times we don't even know what digital assets people have. That's kind of the bigger problem. That's problem A before you even get to how do I collect this.